A company may say a crash was just bad luck, but sometimes the real question is, who decided that driver was safe enough to get behind the wheel? To prove inadequate driver screening, you first connect the driver to the company and show the company had a duty to choose qualified people. That usually means checking hiring records, training files, license history, driving reports, medical paperwork, and past safety complaints. A clean application is not magic armor, especially if the company never checked whether it was true. If a driver claimed years of experience but the record showed repeated crashes, suspended licenses, or serious traffic violations, that could point to careless hiring. The timing matters too, because a company may have ignored warning signs before your accident happened. A missing background check can look very different from a careful review that simply missed one hidden detail. Lawyers often request records through the legal process, including personnel files, safety policies, drug and alcohol testing records, dispatch messages, and driver training documents. Think of it as opening the company's filing cabinet, except the filing cabinet has lawyers and several extremely nervous paper clips. You also need to show that the company's screening failure helped cause your injuries. If the driver had a history of reckless behavior and then caused a crash in a similar way, that connection may become stronger. One old speeding ticket does not automatically prove the company did something wrong. Courts usually look at the full picture, including how serious the past conduct was, how recent it was, and whether a reasonable transportation company should have treated it as a warning. Transportation companies may also have written hiring rules that sound impressive but were not followed in practice. A policy promising careful screening is useful evidence if employees skipped the checks whenever business got busy. You might hear that the driver acted alone and the company cannot be blamed. That argument misses the point when the claim is not only about the crash, but also about the company's decision to hire or keep someone who posed a known risk. Keeping the driver can matter just as much as hiring the driver. If later complaints, collisions, failed tests, or safety violations appeared and the company still sent that person onto the road, the screening story may continue after the first day of employment. Records from government agencies, past employers, witnesses, and other crash investigations can help fill in missing pieces. Sometimes one document is not dramatic, but several small clues together can tell a very loud story. You should also save medical records, photographs, repair bills, witness contact information, and anything showing how the injury changed your work or daily life. Your phone may already be carrying evidence, so do not let important messages vanish into the digital sofa cushions. Companies may argue that the driver passed a standard check, and that can be a serious defense. The key issue may then become whether the check was complete, accurate, current, and suitable for the kind of vehicle and work involved. Because transportation cases can involve federal rules, state laws, insurance companies, and fast-moving evidence, early legal advice can help protect important records. You do not need to solve the whole case at the kitchen table with a calculator and a detective hat. A strong claim usually combines the hiring records, the driver's history, the company's safety practices, and the facts of the crash. If you want to learn more about our company, check out our links in the description.